Good morning, everybody, and welcome to what is the last risk reduction class for 2023. I've already got one scheduled for 2024, but we'll take a little break after this class for a few weeks before we jump into more. But I want to end the year talking about two things. One is the December forms release, which was yesterday, I believe. It was scheduled for yesterday. So the forms I'm going to talk about are already in the CAR form library. I also want to end the class today with a brief discussion of best practices that agents should be following in light of the recent commission lawsuits. And just be sure, I think most of the advice I'm going to give you is a few things that might be a little different than what you're doing, but most of the things I think our agents are practicing now anyway. So I'll give you a little heads up there and talk about what's changed, and more importantly for now, what has not changed. All right, so with that in mind, let's jump right into the new and revised forms. I will share my screen. All right. And let me minimize this and this. And that's my little puppy there on the right. The one on the left is already passed away, had a stroke. All right, so let's go here, slideshow. All right, as always, if you have any questions, problems, issues at all, don't hesitate to reach out to me. Let me make a quick announcement about when you absolutely must reach out to me, and that is if ever certainly if ever you are contacted by an attorney and it has something to do with a potential claim, whether we're involved in the claim or not, it's critical you contact me right away so we get our ducks in a row. You should contact me very early when a client, either your client or the other side, especially at the close of escrow, is threatening some sort of claim or making some sort of allegation, and there may be a potential claim after that. Be sure to reach out to me right away so we can get things on track, resolve it if possible, and just as importantly, not jeopardize your client, yourself, or the brokerage. So be sure to reach out to me when there are potential, what we might call legal issues. Okay. And of course, always reach out to me with your questions about your transactions, your forms, and always happy to help, of course. You can email me. There's my email address. And if it's evenings or weekends, text my cell. And I keep it pretty close to me. If you're working, I try to be available and happy to get back to you on evenings and weekends as necessary. Okay. New and revised forms, the December 23 release. These forms were the new form and the revised forms have been released, I believe, and they were scheduled to be released yesterday afternoon, and they are probably in the library now. So I want to talk about some of the forms. Now, if you look at the handout and if you look at the list, I think this quick summary is about 6 pages long. There's, it looks like to be almost 30 forms that they're talking about. Don't be too overwhelmed by that. CAR has adopted a policy to review every CAR legal to review every single form in our library at least once every 4 years. And in some cases, nothing changes on the form except a revision date. That's the only change. Now, whenever they revise it, like the ones they're looking at now, even if they didn't change the date or the form, they're putting a new date revised as of December 23. And I think that's probably a good idea. Some of these forms have versions that go back more than 10 or 15 years, and CAR wants to make sure that they're looking at all of the forms and making sure they're current. So much of this release, this forms release, it is not really any changes at all to the form. There are several with minor changes, And then there's a handful with a little bit more significant changes, and we're going to talk about those this morning and go through sort of a summary of the forms you probably want to pay attention to, because they are a little different than they were before. So I included in the handout the quick summary. You can review it. I'm going to select some of the forms off of that summary and talk about those forms. So let's jump right into it. The first form I'm going to talk about is the only new form, and it's the buyer's homeowner insurance advisory. So as many of you know, it's getting harder and harder to buy fire insurance, especially, but even just regular homeowner insurance due to water intrusion claims. The insurance industry is really tightening up, and the availability of insurance in California is reduced. And it's getting to be very expensive. I talked to one individual, and their insurance rate went from a little over $1,000 a year to over $30,000 a year on a pretty much a similar house that they're buying, not much bigger, not much different, just in a different neighborhood. And that's having a significant impact on their ability, financial ability, to even buy a home. So this advisory was put together by CAR to be sure that we're advising our buyers to get serious about their homeowners insurance. I tell agents all the time, you should treat your advice to buyers regarding their homeowners insurance the same way you treat your advice to buyers regarding their loan. Specifically, what I'm talking about is right after the offer is accepted, you are telling your buyers, and correctly so, to get with their lender and get the process started immediately. That is necessary with insurance today now, because it can take weeks to find an insurance policy. The old days used to call up an insurance agent and they would bind the property with a phone call. And, those days are gone. So be sure you advise your buyer just in the same way you advise them about lenders, advise them about homeowner insurance. You've got to get on that right away. You've got to shop around. If you're going to shop around, you've got to make sure you can get a policy. You've got to make sure it fits your budget. And so that's substantially what this form is intended to do, to get you on track with talking to your buyers. Right now, homeowner insurance is not a separate contingency. The ability to qualify and the cost and coverage is not a separate contingency in the RPA. It is part of the investigation contingency. That's probably going to change. That probably CAR Legal is going to recommend to the form committee that we change the RPA to add yet another contingency for the buyer and a unique homeowner's insurance contingency. They have modified the CR, the contingency removal form, to allow you to remove all of your investigation contingencies, but reserve the investigation of insurance. And so pay attention to that, sellers. Pay attention that you may think you're getting a complete removal of the investigation contingency, only to discover, oh no, they checked the box, accepting their homeowner's insurance. And then buyers, agents, you can take advantage of that protection, assuming the seller will allow you to do that. Okay, so I'm not going to spend a lot of time on the form. It's pretty straightforward. You can read through it. This bundles with the purchase contract. This prints with the purchase contract, so you'll have this available to you to give to the buyer right away. And that's in red is a little disclosure about some of the problems in getting homeowner insurance. So pretty straightforward, pretty simple form, not a big deal. Okay, well, insurance is a big deal, but the form's not a big deal. It's good to have it. Now, there has been a change in the law regarding listing agreements and the duration of the listing agreement. Currently, only for another week or and a half, you can take a listing for as long as you want to take a listing. After the 1st of January, and I'll talk about more about this next month when I talk about laws, but after the 1st of January, the maximum listing period you can have on a residential property, 1 to 4 units, is 24 months. Now, for most of us, that's not a big deal. Most of us are not even taking 1-year listings. I took 1-year listings most of the time. A lot of you take 6-month listings. A few of you are still taking 90-day listings. So this will not impact you. You should be aware of the fact, and the form it points this out to you. The listing period, of course, is specified on the form. And then there's a little asterisk, and then the asterisk references this notice of about the maximum listing period for residential property, 1 to 4 units, 24 months, unless the seller is a corporation, LLC, or partnership. Now, the other thing that's important, and again, most of us haven't done that, but it's unlawful to record or file a listing agreement with the county recorder. So some of you may be asking, what is this all about? There's actually a Remax Connections agent that was very proactive, helping a client of hers with a problem I'm about to tell you if you haven't heard about it. And the brokerage that did this the most, and they're licensed in multiple states, is M like Michael, V like Victor, Realty, MV Realty. They were taking 40-year listings, and they were recording the listings. And they were giving the seller, most of the sellers were elderly or English wasn't their first language, many of them in financial distress. They were giving these sellers as low as $400 in exchange for the seller listing with MV Realty. And these are unsophisticated sellers, and they weren't planning on selling anyway. They don't care, not listing, but not putting the home on the market, but listing it. So, list the home with MV, but you don't have to sell it. But if you ever do sell it in the next 40 years, you owe us compensation. And one of our agents came upon one of those listings, and boy, was she proactive. MV's headquartered in Florida. She and I talked to the Florida Attorney General's office. We've talked to the California Attorney General's office, and we discovered that we weren't the only people experiencing this problem with potential clients. And so California legislature, to head that off, passed this law limiting the length of time a listing can be, and the fact that you can't record the listing. Because if you record the listing, that's the problem we had. We had to deal with it because the title insurance would not insure the transaction unless this MV Realty released that recording, released their so-called lien on the property. So that's what this is all about, if you're wondering. Most of you are not going to be affected by this. Law also prohibits automatic renewals of listings, and the law also makes any extensions of the listing a maximum of 1 year. All right, so residential property, 1 to 4 units, maximum listing period 24 months. Does not apply to a corporation, LLC, or partnership, and you cannot record a listing agreement in the state of California. All right, now, the modification of terms added this same language, because on the modification of terms, one of the uses of the modification of terms, the MT, is to extend the listing. So you cannot extend the listing for more than an additional 12 months. That's the maximum extension you have. Now, the law reads from the time the listing was signed. So if you signed a listing today, and it doesn't take effect for 3 months, then you're only going to have an active marketable listing, or actually function under the listing for 1 year, 9 months. because it's 2 years or 12 months from the date the listing is signed. All right, so now that I didn't put this in the file in the program today, but this note is also on the RLAN and the RLASR, the seller reserve listing agreement and the open listing agreement. All right, pretty straightforward. SPQ. SPQ has had a couple modifications. One of them is that, whoops, I went the wrong direction. One of them is they've added a question about whether an ADU, excuse me, is properly permitted or not. There are quite a few people that have gone out and made a little ADU or done a garage conversion or an extension, second story on top of their garage without proper permits. And so that has to be disclosed. I want to caution everybody to caution, not only their sellers, but their buyers. If you put a tenant in an ADU that has not been properly permitted and approved by the government, you cannot evict that tenant for non-payment of rent. Now think about that. It is illegal in the state of California to collect rent on a structure that is not properly permitted and doesn't have a certificate of occupancy. So someone builds an ADU and rents it out, but they didn't get it permitted. That tenant doesn't pay them. What do? You evict them. Well, you can't evict anybody for non-payment of rent for a non-permitted ADU, so you cannot get them out. And, good luck collecting the rent. This has happened a couple of times that I'm aware of recently in the state of California, one in LA and one here in Escondido as well. So be sure that if your buyer is thinking of buying a property in ADU and has some thought of they're going to rent that out, you want to be sure your buyer understands they need to confirm that it's been permitted. The seller's obligated to disclose whether it's been permitted or not, because the buyer could have a real problem with a tenant in the future if they put them in that ADU. So although 8D doesn't seem like a real big deal, it can be huge if your client ends up getting burned by putting a tenant in a non-permitted ADU after they bought the property. Okay, now another change is they added a paragraph 18C, whether or not the property was originally a manufactured or mobile home. And the reason they did that is a lot of manufactured and mobile homes have had additions put on them, and they practically look like an out-of-the-ground building in its entirety. And so the fact that it's manufactured or a mobile home may be somewhat obscured by the modifications done to the property. So the Forms Committee added this disclosure so that a buyer who may not be aware of the fact that a home doesn't look like a manufactured or mobile home, especially due to modifications that the seller disclosed that it originally was a manufactured or mobile home. Okay, seller's purchase of replacement property. This is an interesting revision to this form, and I'm not 100% sure I'm in agreement with the concept. I can understand the concept, and I want to talk to you a little bit about, thinking about this with your sellers. Okay, what am I talking about? Okay, seller's purchase of replacement property, the SPRP. They added a clause, look there in red, that the seller will deliver to the buyer at the time they remove the finding replacement property contingency proof that they found the property. And if it's a home they're buying, a copy of the purchase agreement or the information for the of the escrow. And if they're renting a property, they're selling their property, but they decided they couldn't find one, but they still want to sell, so they're renting a copy of the rental agreement. All right, now I'm going to go. So that's now in the contract. And of course, the logic is, and I understand the logic, if the buyer removes his contingency, but in fact doesn't find a home, he still has to sell his home and get out. because he removed the contingency. But if he doesn't have a place to go to, he or she may not be so eager to move out, may stay, may tell the seller, look, I'm not selling after all, sue me. And so Carr's logic, and again, they're not wrong, their logic is the buyer should be aware of that, because the buyer may end up acquiring the home, thinking they're going to move into it, only to find out they're going to have to go to some legal expense to get the seller out. Why? Because it turns out the seller lost the home they were buying. That escrow didn't close, or they didn't find a home to rent because they found out rent's so expensive now that, and they're not getting out like they said they would. And they still are obligated to get out. But the concept is a buyer should be aware, you might have to get, legal help to get them out, especially if they don't have a home to go to. You're not going to need legal help to get a seller to move into their new home. They're going to move. You probably won't need legal help to get a seller to move into the property they rented, because they're not going to rent a property and then not move in. But if they don't have a new home, or they haven't rented something, you might have a problem, even though you have a contractual right to kick them out. You might have to hire an attorney to do it. So Carr made this a requirement of the seller to inform the buyer. And in fact, if the buyer seller's replacement property enters escrow and there's a cancellation, the seller has to tell the buyer there's a cancellation. And then finally, the buyer can cancel if the seller doesn't provide proof of replacement property, or if the seller gives notice to the buyer that the escrow of the seller's replacement property is canceled. All right. So what's my reservation? I'm not 100% in agreement that we should automatically be providing buyers, sellers, future addresses. I think that could be problematic. I can tell you a lot of sellers don't want the buyer to know where they're moving to. And in fact, if a lawsuit is filed, or even they're attempting to file a lawsuit, and we are called on what's the address of your seller on advice of legal counsel going back years, you don't provide that. That is a confidential piece of information. Now, court order, they can go to court and force us to provide, or force escrow to provide a forwarding address. But escrow, as a rule, will not tell a buyer the seller's forwarding address, nor should we. Now, if the seller says, go ahead, we should probably tell the seller, are you sure you want to do that? Buyer might harass you. I'm not saying he will, but that's your choice. And if they don't mind, then I don't want the problem. Yeah, go ahead, give it to them. But I can tell you most sellers don't want buyers to know their forwarding address. So going back to the providing proof that you bought a place, it's going to have the forwarding address. Or provide the rental agreement, it's going to have the address. So the question was asked of Carr Legal, and Carr Legal did agree that this could be either removed from the agreement, or at the very least, perhaps the address itself redacted. Now, they're not 100% sure if you can redact the address if you've complied, because it doesn't say you can redact the address, but they think you can. Well, that's interesting, they think, but they also say maybe you can't. But for sure, no law requires this. This is just an agreement. So if you are concerned about this, don't want to make this into a big deal, but think about it. If you're concerned about it, then you might, if you are using an SPRP, you might amend it to say that the seller shall not provide proof of replacement property, and remove paragraph 5B and 5D from the agreement. You would do that on an addendum to the SPRP. So no, it's a little complicated, and maybe I'm making a fuss over something that most people don't worry about, but I deal a lot of problems after close of escrow, and I can tell you in general, most sellers don't want the buyer to have their address. The buyer can get it if he has to. If he does file a lawsuit, one of the things they can do is serve us an order from the court to provide any information we have relative to how to find the seller. But again, I'm not sure I know for sure we don't volunteer it. Okay. Any questions on that? Got questions? Put it in the chat. Lindsay watches that. We can talk about it at the end. All right, moving ahead, the tenant occupied property addendum, the TOPA. That has also a somewhat significant modification. I want to sort of review that with you a little bit. And that is if the seller is able to remove the tenants, right? So the contract might say that the property sold as with a tenant in the property, but the buyer is buying it to take possession, and the seller has agreed to attempt to put the tenant out, to get the tenant out. And of course, always use a TOPA. Always, 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 anytime any tenant of any kind is in a property you are selling, even if that tenant has already agreed to move out and they're in the process of moving out. But if they're not out when that contract is signed, be sure to include a TOPA, because the TOPA protects the seller that if for any reason the tenant doesn't go out, doesn't get out, the seller's only obligation to the buyer is to compensate them for their physical inspection and their appraisal. Absent a TOPA, the tenant said they would move out, but gee, lo and behold, they changed their mind in the 11th hour. Now they're not getting out. Now the seller's got a problem, because they would be liable to the buyer for the damages the buyer suffers for the tenant not getting out, even if you had a legal right to evict the tenant, but the tenant's still not out. Okay, so if the tenant did move out, this revision requires the seller to disclose whether the tenant vacated voluntarily, or whether the seller paid the tenant to leave, or whether the seller had to file a lawsuit, an unlawful detainer, to get the tenant out, and if the lawsuit ended with a judgment. And the reason for that is courts have held, believe it or not, a homeowner puts a tenant out of a property but does not do it legally, violates the law in some way. And then he sells the home. And then the buyer, he doesn't know anything about it. He's now the new owner, and the tenant goes back against the property, wants to move in. The tenant may have the right to get repossess the property, even if the property's changed hands. That's sounds kind of incredible, but in California, tenants kind of rule. So it's important for the buyer to understand the circumstances by which the tenant was put out of the property, so the tenant can govern their actions accordingly. So that's a pretty significant change, and it's significant because sellers now need to disclose it. It's very significant to buyers, because buyer's agents should review this with a buyer so they're aware of the fact that this tenant was put out voluntarily. Good news. Apparently, tenant agreed to move out, and they provided us a copy of the agreement. It was a cash for keys, and that seemed to look like it was legit. Have the buyer's attorney review it, or no, the tenant in anger left, was locked out because the landlord thought he could do that, and the tenant did vacate, but the tenant's pretty upset about it. See, those kinds of circumstances need to be disclosed. Okay.
Well,
yes.
Quick question. So is it not legal then to pay a tenant to leave?
Well, that's an interesting question, Libby. It's not legal to initiate paying a tenant to leave. It can be deemed as harassment and extortion. So if you notice the cash, I think I talked about it a couple of risk reductions ago, the cash for keys agreement has been modified to make it more that the tenant is willing to leave, and it's voluntary on the tenant's part, and it wasn't some kind of coercion on the seller's part. So what you do is you tell the tenant that you'd like him to leave. He's not obligated to leave, but if he were to leave, you might compensate some of his expenses. You have that kind of a conversation. You let the tenant basically initiate the request for cash for keys. When the tenant initiates the cash for keys, of course, you have to sort of guide them a little bit. Be careful, do it verbally. Now you're okay. Now you can pay them. But if the landlord and you as the agent on behalf of the landlord approach the tenant with, we want you out and we're going to give you money to get out, that is illegal, But you can say to the tenant, boy, it'd be nice if you moved out. You don't have any obligation to move out. But I'm pretty sure the seller would compensate you if you ask. If you send me an email and say, I'm willing to move out if you give me money, now you've got the cart behind the horse where it belongs. Did that answer your question, Libby? Did that help?
Yes, thank you.
Yeah, okay, not a problem. Okay, now, if the tenant's in the property, then this clause has been added to the TOPA and modified a little bit, and especially with things like the deposit. You have to account for what you're doing with the deposit, and so this sort of addresses that. Now, if the tenant is in the property and it's more than one unit, then you still have tenant occupied property for the other units. You have to deal with that accordingly. All right. And then the security deposits, if in fact, now this is not the tenant being the buyer, this is just a tenant. And if the home is transferred with the tenant in place, you have to account to the buyer the status of the deposit and account for any lawful deductions that may have already been made from the deposit by the original owner. So sometimes owners, they have a $2,000 deposit, and the buyers damaged the property and they've agreed to just take that out of the deposit. And so now the deposit's a little smaller. Well, you have to account for where that money went to the new owner, because ultimately the new owner has to account for that to the tenant when the tenant leaves the property. So this paragraph 7's been added as well. Again, if you have any questions about this, especially tenant landlord law, there's been some changes. I'm not reviewing that because as a company, we don't want our agents managing property. So if you are put in a position where you feel it's important that you agree to manage property, and give me a call. We do make a few exceptions. We just want to be sure you understand the rules. But as a policy, we as a company do not encourage our agents to do property management. Now, if you're a broker and managing property under your own license, that's fine. You have every right to do that, and that's okay. But if you're doing it under Mike's name, then you have to call me and let me know about that. We sent an email out, a blast out recently, so you could tell me this, and not to shake our finger at you. What are you doing? You're not supposed to do it, because those are people who are doing it now. They're sort of grandfathered in. But there are some significant changes to the laws that I want to review with all property managers. And so there'll be a notice about that going out to people who have advised us that they are in fact managing property. And again, that notice went out not to in any way, no recriminations for it. It's so that we can be aware, so we can help you stay out of trouble, keep your landlord out of trouble, and keep the brokerage out of trouble. All right. Now, 2 forms that have been changed significantly, but I'm not going to review them in any detail. The HID, which is the for your protection, get a home inspection, which is required by FHA transaction. HUD requires this form to be given to buyers who get FHA loans. And so this form prints when you check the box FHA. It prints automatically and goes out. A lot of agents use this as sort of an inspection advisory, and I'm not opposed to that. You're still going to want, if they're not getting an inspection, you're still going to want the appropriate waivers. But this is required if it's an FHA transaction. Now, interestingly enough, technically, it's really required by the lender. But the lender doesn't always give this out right away. This should be given out with the purchase. Not with the loan docs. So CAR recommends, and in fact, acts on their own recommendation that this print with the RPA and you provide it. It's been totally reworded and reorganized, but it says substantially what it's always said. So that's why the entire form is in red, and I'm not going to review it item by item. There's no need to do that. Okay. Another form that's been changed quite a bit is the delivery of or failure to deliver the short sale lender written consent to the short payoff. So that form has been reworked. This is an example of why cars looking at every form. They're looking at all the forms and looked at this one. They said, holy cow, we've learned a whole lot about how short sales work since the creation of this form. And there's a little better way to organize it. So this form has multiple places you can look at the form. I didn't do a blow up of it, but you can see on your screen, I included the form in your handout. There are multiple places where sellers and buyers sign because each clause has a unique set of circumstances related to it. So they reorganized the form. Right now, the good news is we don't have any short sales going on. If you happen to find yourself in a short sale situation, give me a call. I'll review with you some things, remind you of things you probably already knew, maybe you've forgotten, and we can go through this form in detail if the market requires it. But otherwise, I don't want to take your time, especially before the holiday, on going through this form. You're never going to use it for the next couple of years, I don't think. Okay, let's hope. Now, I also want to talk about, this is not in your hand, I just want to show it to you on the screen, and most of you probably know this, but I'm still getting a lot of questions about this, and it was a little confusing when it first came out, and plus they didn't do it right, they being Lone Wolf, who owns Zip Forms. They didn't quite do it correctly, so it didn't work the way it was supposed to work. They have corrected that, so I'm going to show you what you probably already know. And what am I talking about? Well, I'm talking about paragraph Q, and there are two places on this form where you can specify a provider of what may or may not be a part of the contract. So the first thing is, and I'll remind everybody of this, the natural hazard zone disclosure is required on all California real property transactions. Doesn't matter what kind of property it is, land, 4 units, 1 unit, 10 units, apartment complex, shopping center. A natural hazard zone disclosure is required by law on all real estate transactions. All right, so most of you know that, and Lindsay checks for it, and sometimes we remind an agent who doesn't realize that, oh yeah, they're not exempt because they're a trust selling their 5 units. Well, they're exempt from a TDS, but not from the natural hazard zone disclosure. So on this form, you can click the natural hazard zone provider. So if you click on there, you get a drop-down menu and a choice of companies, and you can click on one of them, and they will be the company that you specify. You can write in the blank some other company if you want. Okay, so pretty straightforward. Some of you are using that now. Where there's some confusion is click for additional reports. There is a Fortress wildfire disclosure, which is not mandatory. I would recommend you provide it to your buyers. It's a nice idea. It does not replace the FHDS. It does not require a fire inspection. There's no agreement that you will get a fire inspection. It's a more of an advisory. It is a disclosure about the property. It includes even aerial views of the property, recommendations of what a buyer should do to the property. So in some ways, I think best business practice would almost dictate we provide this to the buyer. There is a cost to that. And so if you don't want to do it, there's no law that requires it. And for now, I haven't, got myself to making it necessary, trying to keep your life simple. So if you click on not applicable, it won't do anything. I think you can even leave it blank, but certainly you can click on not applicable. That option didn't exist before, and agents were confused because the only option was to click on the Fortress wildfire disclosure. What's that? Why are we doing this? Okay, so you click on not applicable if you want, and it's not applicable. Or If you click on, yes, we're going to do the Fortress wildfire disclosure, you get to pick the company who's going to provide it. And of course, before you do that, you do, after you've checked Fortress wildfire, who's going to pay for it, buyer, seller, both, and then who's going to provide it, and you get a drop down menu there. Hopefully that's pretty straightforward. Probably most of you figured this out, but I've gotten more than a
And
few
Walt,
questions about it. Yes.
can you no longer put seller's choice?
I think you probably could. Yeah. I'm not sure why you couldn't, because Carr tells me, I didn't try it last night when I was finishing up this. I didn't try it, but Carr told me that you can write in those blanks. If these people aren't the company you want to use, you can write in whoever you want. Good question. All right.
Hi, Walt. Where do you
Yes.
put not applicable? Where do you put that here in line?
If you go
Q2?
back to, on Q2, paragraph 3, Q2, if you click there, right, there's a drop down. I don't think I did a screen of what it looks like. Oh yeah, no, that's what it looks like. It looks like, forget the natural hazard providers there. This is what it appears when you are in zip forms making out the form. You're going to see this blue. Click
I
here
see.
for additional report. Carr told me agents can ignore that if they want, because I called them before when this first came up, because you didn't have the not applicable option. And so, yeah, and a couple of agents on the phone with me, we did a workaround kind of, which probably amounted to us basically, I think what they did is they wrote in none, which is sort of, not clicking anything. They just wrote in none on the form. I think they hand wrote it on the form ultimately, but they have corrected that now. So you can ignore it, or you can click on not applicable if you don't want to even get involved in that.
Thank you.
Okay, absolutely. Good question. All right. Now, I did want to review, lots of lawsuits still being filed. It's important to know that there's been no final decision in any of the lawsuits. Most of the lawsuits haven't even been adjudicated, which means haven't even been heard in front of a judge or an adjudicating panel, an arbitrator. If it's an arbitrator, most of these are going in front of juries, actually. So many of them have not even gotten to that level. You all know that the Burnett case, of course, did. That was a debacle in many ways. It was a debacle partly because the judge seemed to be very, very anti-real estate and made some rulings that I am told, and many of you who looked into this have also heard, that judge made some rulings that almost guaranteed, no, there is no guarantee in law, especially, but almost seems to lean heavily into the it's going to be reversed and have to go back to trial if they're going to go back to trial. If it gets reversed, that might induce everybody to settle. Okay, but nonetheless, because of all these things going on, there are some best practices that we can start doing now. There are going to probably be some changes. One change, I'll get ahead of myself a little bit, but 13 states right now, and other states are considering it, California being one of them, making buyer representation. If you're going to represent a buyer, you have to have an agreement with the buyer to do that. Right now, you do not need that, and that is still not necessary, although highly recommended. So let me go through a few best practices real quickly. We'll finish in time to have plenty of time for questions if we have any. Okay, so best business practices regarding the dealing with the issues coming up in the commission lawsuits. So the first thing is, listing agents should at the listing appointment discuss with sellers that the commission is negotiable. One of the things that a lot of critics of the jury and the lawsuits, they are claiming they didn't know that commission is negotiable. I'm not privy to most of the other state forms. Certainly our forms, it's all over the place on our forms that it's negotiable. But Carr is recommending, and I agree, we should verbally be telling sellers, commissions negotiable. We should avoid things like standard or fixed or anything like that. You can say they're completely negotiable and my fee is, period. And you can say, it's negotiable, but I choose not to lower my fee. I mean, we can talk about better dialogue, but you can have that attitude. The fact that it's negotiable doesn't mean you have to lower your fee, but it is imperative that sellers understand they have a right to negotiate. I mean, if they're not very good at it, you're better, then they'll pay you your commission, right? Okay. Now, you should also review with the listing agent, with the seller, the benefits of offering compensation to the buyer's agent. Why? Because there's no requirement any longer to offer compensation to a buyer's agent, and sellers should know that. You do not have to offer anything to a buyer's agent. You can now put in the MLS 0. And again, common to all these lawsuits is sellers thought they had to pay a commission to buyer's agents and they didn't want to. The common complaint of all these lawsuits is, why are we paying the buyer's agent? That agent's working against me. Why am I paying him? Well, there's a lot of very good arguments on why you pay a buyer's agent. And so you can discuss that with a seller, that there is a benefit to paying a buyer's agent. Now, listing agents can offer any amount, as I just said, compensation to the buyer's agent in the MLS, the CBB. It can now be 0. Used to have to be $1, which is practically 0. I know. So that's going to make the buyer representation agreement even more important to those of you representing buyers, because I think as time goes on, you're going to start seeing more and more zeros in the CBB column. I think that's inevitable. Although I will say Washington's had this for a number of years, and they still predominantly, they're averaging over 2% in the CBB field in the Washington State MLS. So I might be wrong. I might be a little too pessimistic. I've been told I'm a lot more pessimistic than I thought I was. So maybe they won't all go to 0. Okay. Now, listing agents should avoid this statement. And, I'm guilty. When I sold that real estate, when I listed houses, part of my presentation was to get the seller to pay a full commission because I'm going to split whatever you pay. And if we don't offer the buyer's agent enough, he's not going to show your house. That is probably one of the things that really, really hurt these lawsuits. And that is what all people pretty much are saying is a very bad practice. It's called steering by commission. And that's practically outlawed. It's NAR has agreed not to allow you to sort property by commission, and CAR is actually recommending you do not, guide your buyer to what houses they should buy based upon commission. So don't say that in a listing presentation. Don't use that dialogue. And so, if you have some challenges there, give me a call. We'll help. We're going to do some classes on the sales side of this in the beginning of the year. I've talked to Mike, and Mike and I are going to work on this. And I think Mike's going to make some great presentations going forward early in the year to help us deal with some of these issues from a sales perspective. All right. The RLA paragraph 3D, which is, paragraph 3 is the compensation paragraph. And 3A is the total commission. So up in the 3A, it's about, about bottom of the top third of the listing agreement. That's where everybody puts theoretically either, 6%, 5%, whatever you're putting down. That's the total commission, your commission plus the buyer's agent's commission. 3D is where you're putting that portion of the total commission to the buyer. So if you're, and I can say this within the company, we're not fixing commission, although we can within the company, but we're not. But if you are charging 6% and want to give 3 to the buyer's agent, you'd put 6. What I say all the time is 6 on top, 3 on bottom. It's 6 in 3A and it's 3 in 3D. Lindsay checks for that. The good news is it's rare. It's rare that that's not filled in. Once in a while, an agent resists that a little bit. You cannot resist that. CAR is in the process of zip forms, modifying zip forms to make it impossible not to fill that in. It has to have a number in there. That's critical. Okay. Buyer's agent should disclose to the buyer the amount of compensation offered to the buyer by the listing agent. That is a lot of agents. That gives a lot of agents heartburn. If you have a buyer broker agreement, the agreement, buyer representation agreement, the agreement requires you to do it, and there's a form to do it, the ABCD form. There's some discussion that the ABCD form may be a requirement in transactions where we tell all of our buyers the commissions on all of the homes we're showing. Because like I said before, perhaps the thing that's most difficult to deal with in these lawsuits, and I say difficult because I personally did not show houses that didn't offer me a good commission. I'm not sure I could do that legally today. And so I'm sympathetic to agents who say, well, why would I show a house that's offering 1%? Well, what you would do is have a buyer broker agreement, a buyer representation agreement for 3, and then explain to the buyer, in this particular house, you're going to owe me 2. That's not what I did. That's not what most of you do. Well, most of you don't steer anyway. I think you just accept whatever is in the listing agreement in the MLS. You cannot steer buyers based upon commission. I'm not sure that's possible today with internet buyers. Oh, we're not going to look at that house because you're not paid enough. That's not going to happen. Okay, buyer's agent should use a BRBC, the buyer representation agreement, when working with buyers. However, the use of it is not required. I was going to put down there, and maybe I should have, at this time. There is discussion that maybe to be compensated for representing a buyer, there must be a buyer representation agreement in place. That may be. So I'm encouraging you to start practicing with it, especially with, you're working with somebody who's, longtime friend, past client, relative, even if you screw up your presentation on the BRBC, they're probably still going to work with you. So get some practice in. We are going to teach some classes starting next year on making buyer presentations, much like you make a listing presentation, because that's probably going to be the way things are done in the future. We'll see. And then finally, if a buyer has signed a BRBC, the buyer representation agreement, the buyer can ask the seller to pay any excess compensation the buyer would owe his or her agent. And you do that in RPA paragraph 3G3. Now, the seller can refuse to pay that excess. That does not alter in any way what is being offered through the MLS. A lot of confusion. 3G3 does not alter the co-op commission in the MLS. It simply is now addressing 3G3 is addressing what would be a buyer closing cost. So you're getting 2% in the MLS. The buyer's agreed to pay you 3%. The buyer has a closing cost of 1%. And just like you can ask the seller to pay the buyer's loan application fee, you can ask the seller to pay the 1% you owe your agent. A buyer can do that. So that's it. Okay. That, folks, completes the class. I hope it was pretty clear to everybody. We're done a little bit early, which is good. If we have any questions, Lindsay, I'm happy to.
Sure. So Nini wants to know regarding the form where you indicate the seller's address for the buyer.
Yeah.
Can you just provide the city and state?
Well, you'd have to modify the contract to do that. See, so you could say, relative to that clause in the SPRP, seller shall only provide city and state. I'm not sure city and state does anything. I don't think it helps the buyer in any way. And if you're not going to provide the address, providing the city and state isn't any better, really, I don't think. And I think from a buyer's perspective, who is worried about, do you have a place to go? Okay, great. You're going to move somewhere to Escondido. That doesn't tell me anything. See, where in Escondido? Do you have a contract yet? Or is it a pipe dream of yours? Going to move to La Jolla. Oh, yeah. On your income? Prove it. Show me an RPA with a La Jolla address.
And
ahead.
Nini also asks, she's heard that the FHDS was going to have changes. Is that true? She's heard the buyers will only have 90 days to complete what is required to be compliant instead of 12 months. Have you heard that?
I've not heard that. The state is looking at modifying. So the reason the FHDS would change is not so much that the FHDS is going to change. It would be a change due to the change in the law. So the legislature is looking at tightening up defensible space requirements, and they may, in fact, be in a position where they're going to require inspections sooner than 1 year. Right now, property is supposed to be inspected every year by a fire authority, but they're not doing it because they don't have enough inspectors. So that may change. Whether you're inspected or not, the law requires you to maintain defensible space. So I always use the example of my house and my firewood. You know, I'm not selling my house. And the only reason I moved my firewood, because you have to keep your firewood, I think 30 feet from your house, maybe 50 feet, I forget. The only reason I moved my firewood, because like everybody else, I had it up, side of my garage, which is kind of stupid, I suppose. But my insurance company made me do it. But it was against the law, literally, to have my firewood next to my garage. But nobody's inspecting it. So the law applies whether you sell a house or not. So the FHDS will change if the law changes, but I'm not sure that the law has yet changed. I'm not aware of it. In fact, I'm pretty sure it hasn't, because I've reviewed the laws that have changed that are going to impact real estate now, and changes to the defensible space law is not one of the laws I was aware of, not on my list.
Do you know what the cost of the Fortress disclosure, the Fortress fire disclosure is?
I knew this question would be asked. I don't have one. I don't know. I apologize for that. You might call a title company, your favorite title company. I'm sorry, your natural hazard company, not title, natural hazard company, and ask them what's the cost of that. So.
And then someone asks, can you explain this more regarding the fire inspection? Because you've always said there's no point of sale inspection for fire.
Right. I'll go through again. And again, if you get any problem at all, don't hesitate to call me. The good news is I've been, I'm going to jinx myself here, but I've been extremely successful in helping the other side understand, no, we do not have to have an inspection, because we don't. So AB 38, which is the law that requires sellers to have an inspection by a fire agency when they sell their house, also includes the provision that the law only applies if there's a local point of sale ordinance. So the state law does not have a point of sale requirement by itself. It says, yes, there's a point of sale requirement if there's a local requirement. Absent a local requirement, there is no point of sale requirement in the law. So you do not need a fire inspection. There's no law that requires homeowners to have a fire inspection. The state wants to do inspections on all properties in high and very high areas, zones. But that's going to be them knocking on your door, not you calling them up and saying, hey, please do my inspection today. The state's going to come to you and say, all right, we're here to inspect your property. They initially thought they would do that pretty easily, but they realized, oh my gosh, there's far too many properties to inspect, and they don't have a big enough staff to do it. So now they're sort of piecemealing it. They are looking at some properties in some jurisdictions, but they're basically responding to requests. Does that answer the question? I'm not sure who asked it.
I don't know who asked it either. It's an iPhone.
If they didn't answer the question, speak up.
Well,
The same person asked, so what is the Fortress fire report for?
It's more of, it is a disclosure, because it discloses all kinds of information about the property. It is think of it as an advisory more than anything else. It advises the homeowner what their, what the status of their property is relative to defensible space. So it includes aerial photographs of your property, and it talks about things that you can do to mitigate the potential fire, having a fire related event on your property. So it's a disclosure in the sense it discloses a lot of information, but it really functions as an advisory. It does not, here's the important key, it does not cause a buyer or a seller to have to do anything to their property. So it's not an obligation to do anything. It's more of a, here's what you can do, here's what you got, here's what it looks like, here's what you need to be aware of. But it doesn't change a buyer or seller's obligation.
And just an FYI, Walt, Holly Surway,
Yeah.
who's a TC,
Yes,
she mentioned that the Fortress fire report is $140.
140.
Just
Thank
for
you very
everyone's
much, Holly.
information.
Appreciate it.
And then let's see, Emily Zach was wondering regarding the buyer broker compensation.
Mhm.
Could you say to the seller, a nice compensation to the buyer's agent is enticing to realtors?
I wouldn't phrase it that way. Now, you're talking to your seller
Yes.
about, well, you wouldn't be talking to your seller about a buyer representation agreement. You'd be talking to a seller about what they're going to offer in the MLS. See, the buyer representation agreement is the buyer's obligation to pay you. The only connection it has to the MLS is it does say in the boilerplate that anything you're paid by the listing side of a transaction is deducted from what the buyer owes. So if you sign a buyer up on a buyer representation agreement for 2%, and the MLS gives you 2%, the buyer owes you 0. In fact, if you sign a buyer broker agreement, buyer representation agreement for 2%, and the MLS says 2.5%, the boilerplate of the buyer representation agreement says you get to keep that extra half. There's a box to check.
No, my question was
Go ahead.
my question was more, you said for us not to say that people won't show the property if it's at 1% or 2%. You aren't supposed to say that. So my question was, can we do the reverse and say how enticing it is if we do have a great percent being offered to the buyer's agent?
Yeah, I suppose if you're careful, what's more to the key is, yeah. So buyers are going to, this is where the buyer gets compensation. Of course, they're going to look at it. It's enticing to a buyer. I suppose you can say that. I'm trying to think through it. What you don't want to say is buyer's agents won't show your property. That's steering. But if you said, you can attract the very best buyer agents, perhaps, get the buyer's agent's attention. Talk about the benefit of paying the compensation of having the buyer have a buyer's agent, and many buyers can't afford a buyer's agent. So if you don't compensate a buyer's agent, the buyer may buy it without an agent, and that's going to be a much more problematic transaction. Sort of go in that direction mostly. Does that help?
Thanks.
But I think enticing is probably okay. Yeah.
Emily, do you want to ask him your other 2 questions?
No, you go ahead.
Oh, okay. Emily also asks, did you really mean that the homeowner's insurance went from $1,000 to $30,000 a year?
Yeah, it went from $1,200 to $30,000. They were paying $1,200 on the home they owned, and their new policy is going to be just under 30 grand. Now, the reason it went way up is it's in a fire district, and they're shopping around. That was with the insurance company they had. They're not going to go with that insurance company, I'm pretty certain.
And then Emily also asks, what if the neighbors have their wood up against their house, closest side to the house listed for sale?
Yeah, the obligations of a homeowner to comply with the defensible space ends at the property line. So when you say what if, well, what if? I mean, the neighbor's house might catch on fire. And then if the neighbor's house catches on fire, your house might catch on fire. I can see that. But you have no obligation to, make the neighbor move his firewood.
All the questions on my end, unless
All
anyone
right.
has any other questions.
I do have one.
Go ahead.
Okay.
Uh.
You tell us, and I'm not saying you're wrong, but you tell us that we don't need a AB 38 inspection, but when you talk to the other side about it, they say, yeah, you do. You have the state law. You call the city, and the city, because this happened to me a couple of times, the city says we've adopted the state requirement. So yes, you do have to have one. Now you've got the city telling the broker on the other side, you need to have one. But and we're telling them, no, our broker said you don't need one because of the ordinance law. I mean, that's really tough to try to, to go on that and explain it where
Is
they
there a way
will
we can
agree.
transfer, can we transfer that to the buyer's side to take care of?
No.
I
if you're not
also
gonna-
heard
Let me,
there's
let me,
more
wait. Let me address something right away because, sometimes I'm not as careful as I should be with the words, but usually I am, especially when I'm talking one-on-one, it's legal. I do not say you don't need to do it. I say it's not required. Because I don't know what they need to do or not need to do. I don't know what the buyer's needs are and the seller's needs are. If you're going to lose sleep every night, unless you have a fire report saying your property's okay, well, then you as the buyer need one. You as the seller might want one. You need one. See, so my first thing I'd say, Ron, is I don't tell the other side, we don't need to do that. What I do say, and I am pretty careful when I talk to them, there is no requirement to do it, and the seller is choosing not to do it. So that's number one. Number two, yeah, no, that's the problem. That's why agents will always tell you that, yeah, you do have to do it. It is required. Because if you call, I've talked to the city manager, the city attorney, talked to him twice. Both times he told me it's absolutely required. Both times I said, give me the San Diego Municipal Code that says that. And I've said it to him, look, I'd love for you to tell me that because I'll tell everybody in the company, yes, it's a city law, you got to do it. So just give me the code. You know what he says? On both occasions, AB 38. That's not a city code. That is a state code. So the city attorney will tell you, yeah, we are following AB 38. Well, that's your opinion. Has the city council passed a ordinance requiring it? And again, I'm actually not opposed to sellers doing it. I am opposed to misinforming sellers. You have to do this. I would argue that's not accurate. And why would I make an inaccurate statement to a seller? I start every conversation with the authorities, especially. Please understand, I'm not against doing these things. I think they're good ideas. I live in a high fire district. I've evacuated my house twice. Houses a block away from me have burned to the ground. So I'm not opposed to doing it. I just, maybe I'm being a stickler for the law, but the law says if there's a sale requirement, then the seller must do it. And if there isn't one, the seller doesn't have to do it. He can voluntarily do it. I can't tell him you have to do this. That's not accurate. So that's kind of the conversation I have. And I'll call the city one more time to see if they've adopted an ordinance, if they have one. But when they tell me, yeah, you have to do it, they need to give me the ordinance, and it's got to start with SDMC. It's got to be a San Diego Municipal Code. It can't be AB 38. Now, could they pass a law saying the city of San Diego is adopting all the requirements AB 38? Well, that's sort of circular logic because AB 38 says if there's a point of sale, then this applies. But if there isn't one, it doesn't apply. So which part of that statement are you adopting? So I don't think although the city attorney hasn't impressed me, I don't think they're gonna write a law like that. They're simply gonna write a law saying, we require a point of sale inspection. 3 municipalities have done that. Truckee, Paradise, and Big Bear. They've done that. But statewide, to last I heard, and the last time we've talked about it, it's probably been a month with Car Legal. Car Legal will tell you statewide, it is not common that municipalities or local jurisdictions have adopted a point of sale ordinance. They haven't done it. So, but again, I wouldn't argue you don't need to do it. I would argue, look, this is something you might want to do. It does incur costs. The good news is the delay is no longer a big factor. They're pretty quick. Initially, I was concerned about delay because they didn't have enough inspectors. Hope that helps.
Walt, I heard that some sellers are now getting sued because they didn't have a fire inspection and the buyer's saying that, they didn't know. So it's like more of a disclosure that the seller didn't disclose what was needed to be done to that property for compliance. So they're coming after the seller.
If there is such a lawsuit, I need to see it. I can see that there might be lawsuits filed relative to this. But first of all, a seller can't disclose what they don't know. Second of all, state law says a seller has zero obligation to do an investigation for the buyer. So the seller does not need to, look, I need to tell you what you need to do to this property after you buy it. That's contrary to law now. So now, could a buyer sue a seller because the seller didn't disclose that they're under the jurisdiction of a management ordinance? Absolutely. That's why we require the FHDS. And that's why I tell agents all the time, and I've done it many times on these seminars, do not check, it does not apply. Check, it does apply. Every property in San Diego County is affected by vegetation management ordinance, every single one. Then the very next thing it says, is the seller aware of anything? Well, awareness, if you have an inspection, you're aware. If you don't have an inspection, you're not aware. You don't know. So the boilerplate is the seller's not aware of any violations of the defensible space requirements. Why? Because they don't have an inspection telling them. If they have an inspection, then they have two choices. One, yes, we do have a problem, or yes, but we don't have a problem. Yes, I am aware and I'm in violation. Or yes, I do have an inspection and I'm not in violation. That's B and C of paragraph 2 of the paragraph 3 of the FHDS. So if a seller's not done an inspection, you can't disclose what you don't know. So I don't know. I mean, I read lawsuits all the time. I enjoy doing it. Send me whatever you have about a lawsuit, because I suspect it has more to do with not disclosing that they were under the jurisdiction of a vegetation management ordinance. That I could see that being actionable, but it couldn't be actionable that you didn't tell us the problems with your property unless they could prove you knew it. That you did have an inspector, but you didn't tell them. See, it's just like you're not going to be sued because you didn't tell them you have a problem with your house if you didn't know you had a problem with the house. You're going to be sued if you did a physical inspection on your house and if you had a problem, but you didn't tell the buyer that. Now you're going to be sued, but not if you don't know.
Hey, Walt, this is Jeannie Dominguez. Hi, can I ask you a question about that Fortress fire disclosure?
No.
Is that no?
Yes.
Okay, so that's something new. Should we advise our sellers not to agree to that, or is that just part of the NHD disclosure that comes up? I'm a little fuzzy on this since this is brand new.
So here's what I want to sort of pontificate a little bit here, and then I'm not going to tell a seller what to do or not to do. I would never advise a seller don't do that.
Okay,
that's going to get you in trouble. Because they get sued for not doing something. Well, my agent said don't do it. I'm going to say, here's the downside, here's the upside. The upside is the buyer wants it. The upside is that maybe the buyer gets a lot of information about the property, and that's good news. The downside could be maybe he gets information about the property he doesn't like and he doesn't buy your house. Downside is you gotta pay 100 and how much was it, Lindsay? 100 and,
100.
yeah, whatever it is. See,
140.
upside and downside, there's not a, you know, don't do this, you know, I mean, something like that. So
Right.
I would review with a seller.
So then,
Go ahead.
okay. No, so I guess then my question is, if we do this on one transaction and that transaction falls out, then we have to provide this document to
absolutely.
the next person.
Oh, yes.
Okay, and so I was worried, like, if it's, and I'm not sure exactly what the Fortress Fire Report is for. Is that kind of like what you need to do to make your house compliant for dispensable space regulations? Is that what it's for?
I believe that I believe for sure generically it says that. Now, whether it says specifically you have to do that. So generically, you have to chop all the weeds down around your house. Now,
Mhm.
whether it says your house has a lot of weeds around it, they do aerial photography, I'm told. So maybe they do that. I had not seen a report. So do they do something very, very specific? I'm not sure. But for sure, generically, yeah, if they took a picture of my house before I moved my wood, do they say, Walt, your wood's too close? I don't know. But for sure, they're going to say, Walt, your wood needs to be 50 feet from your house. Does that help?
Walt,
Does that
a
help?
quick question here. So if you're when you're working with seller and buyer's agent requests that, can we say seller not to provide it? And would the buyer be able to get this report on their own?
Yeah, I think the way I'd counter that out is seller shall not pay for the Fortress Fire Report. Buyer may order it on their own. Yeah.
Thank you.
I think, folks, along on this subject, and it sort of bleeds in a little bit to the defensible space, because there are times when, as a buyer's agent, we need to tell the buyer, you want to get an inspection. You're buying 6 acres in Ramona, and there's a bunch of dead trees out there in the South 40 or something. You know, a lot of brush. You might want to get this inspection. I think the same thing could be true of this fortress when you represent buyers. As a buyer's agent, you certainly want to tell the buyer it exists, you know, and then you would say to the buyer, this is something you might want to ask for. Seller could refuse. You know, maybe you don't want to ask for it, but for sure, I want you to know this exists. So I think that's pretty important, because I think standard of care, the buyer would able to say correctly, I had no clue that I could order such a thing. That could work against us in a claim. But as a listing agent, you don't have to pay it, pay for it. As a seller, rather, I'm sorry. And it's not a government inspection, so it's not prohibited. It's not, the government's not doing the inspection. It's a private party. And so it's legal for the buyer to do it.
That's all.
Contractually. Any other questions? Boy, we certainly kicked that around a lot. Hope it was helpful. If you disagree with me, call me up, convince me. Otherwise, I hope I'm not taking any positions that are controversial. Just want to give you a broad perspective. And to that end, we'll wrap this up for the year. I will we'll be sending out some notices in the first of the year about some additional classes. We'll be doing another class on the new laws. There's a few laws you want to be aware of, but none of them, most of them don't go into effect right away that you need to worry about. And so have a great holiday, a great New Year's. Stay safe. Call if you get lonely.
Happy holidays.
Happy holidays.
Happy holidays,
Bye,
everybody.
Christmas.
Thanks for everything, Walt.
Merry
Thanks, Lindsay.
Christmas. Thank you, Walt.
Welcome.
Thank you
Thanks,
all.
Walt.